Welcome to Advocates for Justice, Foreclosure Defense Paralegal Service. We are different and we prove it. Today we're going to talk about a couple of things. But before we get to that, if this is your first visit, please subscribe, like, and share. I think we got a subscribe button down there someplace for you to click on. This helps people see, it helps YouTube be able to, you guys find value in my channel and what I'm sharing here. So let's just get right into it. Today we're going to cover three things mainly. First, we're going to go over how to prove the attorney's not working for the bank. And second, we're going to talk about a little bit about why I do not add all the nuts and bolts of your case into my lawsuit package. You know, all of the, how the loan modification went and all those things. And we're going to talk about why I don't add all those things into. And third, we're going to talk a little bit about how to handle it when the clerk refuses to accept your documents. So let's just get right into it. How to prove the attorney is not working for the bank. That's the first thing we're going to talk about. So the way you prove that is you check the signatures on the documents that are used to start the foreclosure against your property. Yeah, check the signatures. The signatures on that document used to initiate the foreclosure against your property. In a non-judicial, it would be the notice of default letter. In a judicial foreclosure, it would be the petition. You want to make sure whoever's signature is on those two documents, that would be the signature that you would use as the number one defendant in your lawsuit. And if you check, you'll find out that those signatures are from the attorneys. The bank never signs anything, and the attorneys can't prove agency. They can't verify that they were hired by the bank to do anything. When you look at the paperwork that they filed against you in court, it looks like the attorney's the one that's actually filed a lawsuit against your property. And that's actually what's going on. And the attorney's acting as a debt collector. And he did not, or they did not file on behalf of the bank. And that's what you'll find out when you check your paperwork. Now, the reason I don't list all what's going on, what went on in your foreclosure before you came to us, there's a couple of reasons why. One of the reasons why we don't use all the documents that you have that they provided to you, all of the accounting, the bank's records or whatever, we don't use those, because when you do and you go in arguing all the things that they're saying, then you're verifying that there was a contract between you and the bank. And there was no contract. The bank never signed any contract. As a matter of fact, in my opinion, the alleged loan was actually created with your own signature. And if you'll look at that promissory note, on that promissory note, it'll have a little stamp on it, say paid to the order of, and then an official from the bank, usually the bank president or somebody, vice president, signs it. They turn that into security, and that would be like a check. And they process it through the Federal Reserves, and they were actually, that person who signed was given the electronic credits, which is what they're saying was the loan. Okay, the bank never made you a loan. That's the problem. And when you go into court and you're arguing all their stuff, then you're actually verifying that there was a loan. There was a contract that you had with them. And the interesting thing is that they never filed this contract in court. They don't file the contract or accounting of the money trail or any of that stuff in court. And what they do file in court only had the signature of one person on it, and that's you. The promissory note only has your signature and nobody from the bank signs it. So that's the issue, right? We use against them. You have to make sure you are addressing the things that the attorneys did wrong. You have to address their fraudulent activity in court. If you don't do that, you'll never have a chance. You'll always be struggling. And what we like to do is address that fraudulent activity in a way that sets you up for your appeal, okay? Because in a conventional foreclosure program, you wouldn't have anything on the record to appeal at the end of the road when they threw you out. And that's the way they have it set up. So we're going to teach you how to do that a little bit different. One of the goals is to challenge the court's jurisdiction and get your facts on the record for that appeal. And then that way, when you're doing the appeal, you're actually appealing the court, the judge ignoring the jurisdiction, or the judge ignoring all of these fraudulent activities that the attorneys have been doing. That's what you want to have on the record to do your appeal. So you need to keep that in mind. One of the things that we're going to talk about too is how to handle it when the clerk refuses to file your document. Now, you may run into this when you're filing my stuff, because they don't like, attorneys and bar members don't like to go after each other. And what you're going to be doing is going after the attorney for filing this, for filing the foreclosure against your property, acting as a debt collector without any consideration in the alleged debt that they're coming after you for. So that's totally illegal. And that's what you're going to be going after them for. But anyway, so when you file this in, when you file documents in court, sometimes the clerk tries to, interfere. If they don't, if you're filing that sanction motion against the attorneys, sometimes they will try their best to get out of filing that. And so whenever the clerk's giving you a hard time about filing documents, what you want to do is you want to, first of all, I would always take a little notepad, the little notepad the police use when they show up and start asking questions. And when they flip out that little notepad and start writing stuff down, you know that they're writing down stuff that they're going to come back and talk to you about if it's a problem. So what about your notepad when you go to the court, and if they're giving you a hard time, then you want to ask them what their name is and their employee number, some kind of way that you can identify them if your legal team decides that they need to be added to the claim, if they're blocking you from addressing the issue. So what you want to do, whip out your pad, get the information, because you always want to know who you're talking to, who you about to add to the program. Okay, and then you want to ask the clerk, I just want to ask you, do you have authority to make a legal determination on my document? And you have to write that down and make sure you say it that way. Do you have authority to make a legal determination on my document? Because they do not. They have to file your stuff and let the judge make a ruling on it. But they can't not accept your document. And just, that's it, forget it. Okay. I had a guy that went to file his stuff in federal court, and they were giving him a hard time. They went and looked at, he handed them everything at the same time. They went back, they file stamped everything. They came back, then they got to looking at it, and they told him they couldn't accept it. They weren't going to file it for him. Of course, he'd already given it to him. So he just told them, well, you guys are on the camera right there accepting it. I'm not taking it back. So, and he actually, started to leave. And according to his story, they got mad and threw his stuff in a trash can while he was leaving. And I think sometimes they do this stuff to see if they can get you to be angry, so they can, call the security in and throw you out or whatever. But he just went out and got in his car, so now smoked a cigarette. He said by the time he was done smoking a cigarette, they called him on the phone. They called him on the phone to let him know that they had talked to a pro se attorney that handles the pro se cases, and the attorney told them that they should accept it. So they went ahead and filed this document on the record. But anyway, that's just a little story to keep in mind if you're ever in that situation where they're refusing to file your document. Once you give it to them, you don't have to take it back. And if you take it back, then you're agreeing with them that it shouldn't be filed. And you have to remember, when you're dealing with the court, you're always in agreement unless you unagree. Okay, that don't make sense, but we're gonna leave it like that because the whole program don't make sense of what they're doing to us. So if you're ready to file your lawsuit and get control of your foreclosure, head over to my website at winincourtnow.com and get what you need to get control of your foreclosure situation today. Oh yeah, my next video, we're going to go over the foreclosure process in South Carolina and introduce our new lawsuit package for South Carolina. I had a person on my YouTube video ask me if I would review the foreclosure process for South Carolina. And that's perfect because I would like to be talking about things that people want to know about. So I already got started on that research, and it's very interesting. I'm already in the rabbit hole. It's going to be very interesting. So you don't want to miss that. Thank you guys. I will see you in the next video. Please make sure you like, share, and subscribe. Yeah, that was the other thing. Like, share, and subscribe. That way YouTube will love me because I want them to love me. Thank you guys. Have a great day.